Judge, what's your legal analysis of this? I mean, a lot of different directions to go, but with your mind, what strikes you about what's going on here?
Well, the people that you just saw in front of the Capitol building basically said to Kevin McCarthy, if you want to stay as Speaker of the House, you better allow us to go where the evidence is taking us on the impeachment of Joe Biden. We know you don't want this, but you won't be Speaker if you don't do that. They have a rule in the House that allows any one member to declare the chair vacant.
Judge, can I get you to hang on just a second? I'm sorry. Rick Scott
Sure.
here. Continue your thoughts here, Judge.
Sure. I mean, they're angry, and rightly so. And some of their anger is at other Republicans. So by twisting Kevin McCarthy's arm, you want to stay as Speaker. Let us go where the evidence is leading us on this impeachment. Now, impeachment, of course, in this case, has to do with impeaching him now for when he was vice president. We know somebody can be impeached after they don't hold the job any longer. Donald Trump's second impeachment was after he had left the White House. What purpose would be served? Well, from the Republican perspective, two purposes. One, the revelation of evidence of very tawdry behavior on the part of then Vice President Biden. Even if it's criminal, he's fortunate. It's more than 5 years, so the statute of limitations has expired, but he can be impeached. Can't be removed from office as president. But the second penalty for impeachment, if he's convicted in the Senate, a big if, of course, is invalidation from seeking federal office. So if he's impeached by the House and convicted in the Senate, he would be barred from running for re-election. What a perfect storm. The incumbent Democrat has an impeachment pending. The likely Republican nominee has 4 indictments pending. And the American public is saying, we're going to go through this again?
Yeah, and speaking of the potential GOP nominee, former President Trump, as we know, and as you referenced, he has legal cases ahead of him. But his legal team most recently has filed a motion to have Judge Chutkan recused in his 2020 election interference case. Do you think there's any likelihood of that happening? Is that a good tactic?
Well, I don't blame them for making the argument. It allows them to get out ahead of the curve and articulate all of their complaints about the judge. However, recusal motions are made to the judge whose recusal you want. So they're asking her to recuse herself by finding that she is somehow biased against him. The chances of her doing that are none and none. You can appeal that decision to the appellate court, but the appellate courts just rarely get involved in a decision like that. So basically, they're just going through the motion. But part of their strategy is to bury her. I don't mean literally, but I mean inundate her with motions, forcing her to make a lot of decisions in the hope that if he's convicted, some of those decisions will be found to be wrong, and then they have an appealable event.
You know, the case in Georgia seems like it's so complicated, Netflix wouldn't take it. You know, it's so
nicely put, Mr. Home Run Hitter. Yes, it is complicated, and it's the duty of this 36-year-old judge with 6 months experience on the bench to explain it to jurors so that they can understand it.
Yeah, so it was leading to my question, which of these cases is actually the biggest threat to former President Trump that actually may happen and happen before the election next year?
I think the January 6th case, you just showed a picture of Judge Chutkan. That's the judge whose recusal they're seeking, is the biggest threat to him. But the most dangerous case, the one most likely to end up in incarceration upon conviction, is Mar-a-Lago. Why do I say that? I don't know if he's going to be convicted. A lot of his own employees are going to testify against him. But nobody, take it to the bank, nobody has been convicted under that espionage statute since 1947 and has not gone to jail. So those are the two he has to worry about the most. Georgia is very complicated. The one in New York, I'm not even sure the prosecutors are continuing to take it seriously.
Yeah, and the documents case, Mar-a-Lago, isn't that about isn't the biggest threat defying a subpoena? I mean, you can make arguments, but doesn't that set aside from the espionage aspect of it?
Yes, defying the subpoena by unlawful means is the allegation there. That's the so-called cover-up, asking your employees, and the employees are going to give this testimony, to erase videotapes of boxes of documents being moved. The principal charge is unlawful retention of NDI, National Defense Information. NDI can't be declassified, so it doesn't matter what the then president or former president thought of it.
Yeah.
It's very retention by anyone outside of a secure federal facility is criminal.
All right. And again, we're just talking about these possibilities. We're not putting the cart in front of the horse. We're just talking
Oh, no,
about.
not at all.
Just
There's a
hypotheticals.
lot of ground to be covered before jurors are put in that jury box,
Yeah.
Bob. All
Yeah.
the cases will be narrowed down before they actually come to trial.